the state of Utah doesn't have a cap.
Right.
It doesn't have a cap on damages and hasn't for a long time. I don't know if they're one of the states that declared it unconstitutional or they just never did it. A legislature, Representative Katie Hall, she decided that she would put in a bill to cap payouts to victims at $1 million. And it unleashed a furor. The headline I read, the byline is, quote, "This bill is to protect the rich." And the bill was killed. And the cap was $1 million. Louisiana's cap from 1975 is 500, is half that. And the $1 million cap was described as outrageous. It was described as devastating. And here we have in Louisiana a cap of less than half that. What did you make of that?
I always wonder, where's our outrage? Do you know, what?
Exactly. And you know what the problem is, Chip, though? You're right. We have a constituency that is undetermined until it happens to them or a family member of theirs. Now, the one thing I will say that is occurring, and I think I see it, and I think we all do, is more and more people are having family members or close friends subject to medical negligence.
Welcome to Bayou Justice, Breaking Victims, Protecting Power. I'm your host, Chip Wagar, a medical malpractice attorney dedicated to reforming Louisiana's healthcare laws. On this show, we dive deep into the challenges faced by patients in our state, exploring how current laws often favor institutions over individuals. Each episode will bring you compelling stories from victims, insights from legal experts, and perspectives from lawmakers. Join us as we work to shed light on these issues and push for meaningful change in the Bayou State. Hello, everybody. I'm your host, Chip Wagar, and welcome to Bayou Justice, Breaking Victims and Protecting Power. Another episode today that's sponsored by the Patient Rights Advocacy Forum, whose mission it is to reform Louisiana's ancient and restrictive medical malpractice statute for reasons that you're finding out during this series. And today I have with me two veteran medical malpractice warriors for victims in Louisiana. On the right is Kara Samuels. Kara originally from St. Louis, but came to New Orleans, went to Loyola University, I believe, Kara.
Yes.
And she had an undergraduate degree in drama and speech, as I understand it, which probably serves you well as a trial lawyer. But she eventually got her law degree and decided to stay here, and has been practicing in New Orleans with a major focus, maybe your primary focus. I know you do some other things, but primary focus has been medical malpractice for many years. Is that right?
Yes, that's true.
And then on the left, we have another veteran, Carey Wicker. Carey comes from a storied legal family. Both his father and mother were lawyers and judges. He is married to a lawyer and an appellate court judge. And he has a son, one son or more than one son?
One son's a lawyer, yes.
One son is a lawyer.
Yes.
So Carey is surrounded by lawyers and is a lawyer himself. And Carey, like myself, started off doing defense work. And then, as I did, segued into, over the years, into doing work for taking cases for victims of medical malpractice, which he's been doing, and his firm has been doing at Capitelli and Wicker for many years now. Welcome to the show, you guys, and thanks for being here with us today.
Thanks for having us.
So I want to talk a little bit about a subject a lot of people have misconceptions about. It's informed consent. Informed consent is part of medical malpractice, or can be part of a medical malpractice case. And sometimes it's really not part of a medical malpractice case, but we'll come to that in a few minutes. But a lot of people think that when they sign an informed consent form before their surgery or something, they're basically signing all the rights away. Kara, why don't you talk a little bit about that? Are they really signing all their rights away?
No, certainly not. But I think a lot of lay people do get that impression when you're asked before, a simple oral surgery procedure on your mouth to sign a form that says, I acknowledge I could die or, have a brain injury. I think a lot of us just skim over those forms. But then when something does go wrong, there are any number of people who will say, well, I consented, I consented. So despite that the surgeon did something very negligent in the procedure that injured the patient, they don't think that they can sue because they think that the consent form they signed operates as a waiver of a potential malpractice claim.
And that's not true.
Right. It's not true at all. And in fact, Louisiana law, Civil Code Article 2004, provides that we contracts like that in our state are illegal. If you can't sign your rights away in case you got injured, that would be it's against our public policy. But those forms when they circulate, I mean, they're around for everything. If you take your kid to a bouncy house, they have you sign a form that says, I acknowledge there's a limitation of liability. And I think we've just become so accustomed to signing them, we think that we don't have rights when we do.
And Kara, I think you've had some experience with doctors who gather together every now and then to formulate these forms that they also think it provides them with blanket immunity. Isn't that right?
So they did. So I served, I think about 4 years on a board that's appointed by the government. That's the Medical Disclosure Panel, it's called. And the job of this committee, which is primarily composed of doctors and I think 5 attorneys, is to look at these forms and make sure that the patient understands what are the acceptable risks of the procedure, right? And the doctors on that panel, I often found, much to my frustration, would talk in terms of things they wanted added to the form. And they would say things like, well, we need to make sure we add blindness so they can't sue for that. We need to make sure we add such and such so they can't sue for that. And the lawyers are going, that's not what these forms mean at all. Like, this is not what this means. So I think it's beyond just lay people. I think people in the medical profession construe them that way also.
Carrie, a lot of people think that informed consent involves a signature on a piece of paper, but to do informed consent properly, for an informed consent to be properly done, it's more than just signing a piece of paper, isn't it?
It is. And let me add to what Kara said is absolutely 100% correct. But let me add to the bigger problem, which is not only do the patients and the doctors have a misapprehension as to the significance of these forms, the jurors who sit on these cases, they have a misapprehension as to the significance of these forms, which impacts the patient's claims daily. In other words, there is the best weapon, many would argue, that a healthcare provider has in a medical malpractice case is the consent form. Because the defense lawyer gets up and says, see, this is their signature. They consented to this. Well, they consented to that as a known risk, which means that this can occur even when the doctor does everything right. What they did not consent to, however, which is the most important part of this, they did not consent to negligent care. You cannot, as Kara said, Article 2004 says, you cannot consent in advance to negligent conduct. That's contrary to public policy. But the problem is it is misconstrued by many, many people, and most importantly, the jurors. And the jurors often find that because that's the patient's signature on that form, they consented to that outcome. The doctor still has an obligation to perform the procedure correctly, and they also have an obligation, though, even though those risks are outlined in the consent form, they have an obligation to take all prudent steps to prevent that risk from occurring. And if they don't do that, they are liable, whether the form is signed or not, plain and simple.
Now, Carrie has mentioned something, Kara, that a defense lawyer could use the consent form to absolve his client of negligence, of malpractice, of medical malpractice. Do they really do that? And maybe you could talk a little bit about a case that you argued recently and was in October was decided, the Lucas case. Could you tell our listeners a little bit, do they really do that?
Yes. So we had a case involving a really sad case. It was an elective cardiac procedure. And the consent form, of course, spelled out, you could die, you could have a stroke, et cetera, et cetera. So the woman, she was put under general anesthesia, and as they're intubating her with the NG tube, it gets, I guess, encountered a little resistance, our experts say must have, and pushed it straight through the esophageal junction. And so the surgeon did his midline incision and went into the anatomy, and there's all this blood and the tube exactly where it's not supposed to be. So the procedure gets aborted. She never has the heart procedure she's supposed to. And because of the location of the tear through her esophagus being right at the opening where your stomach is, it became impossible for her to eat or take nutrition over the next couple weeks, and she never really recovered from it, and she ended up dying. It was very sad. And like I said, she never even got the procedure she was in there for in the first place. So we litigated the case for a long time, bunch of different kinds of issues in and out of the courts of appeal. We had a trial setting, and we filed a motion to exclude the consent form under a case called Matranga, which was your case, Chip. And we said, this is confusing. The jury's going to get totally the idea. They're going to think our client consented to malpractice, which of course you can't do. And
let me stop you there for a second, because that issue would never happen unless the doctor or the hospital's lawyer brought it up and waved it around, right? I mean, if they didn't do that, then you wouldn't need to try and exclude it. But they,
right.
But they do, don't
in
they?
Every single deposition, right? We get into with the medical review panelists, and they're going, "Isn't it? Did you look at this? And doesn't it?"
Start your signature.
And it says here, "You can die," doesn't it? Right?
And you signed this, knowingly signed this.
Right, and then kind of acting like, "Oh, this is easy for me." Whoa, got this magic little form, and this isn't really a case anymore for the plaintiff. So yes, we filed the motion in limine. The trial court denied the motion in limine, and we were
And for those of our
stunned.
viewers who don't know what a motion in limine is, that's a basically
Motion
like
to exclude it,
or
yes.
in criminal law,
Yeah.
like a motion to suppress evidence because it's not relevant and,
Yes.
it's prejudicial and so forth. Yeah, okay, go ahead.
Right. So at the outset, we're telling the judge, hey, we can't have a trial where this form gets waved around, or we'll have to do the whole trial over, basically. So we thought we had a straightforward argument with it. The judge denied it, and we got it overturned in the Court of Appeal. And I think one of the things that the Court of Appeal really honed in on was we point blank asked defense counsel to articulate during the oral argument, what purpose are you offering it for, right? Why is it relevant in your mind, to your way of thinking? What are you, right? If we all have evidence and it has to prove or disprove an element of a party's claim or defense to get it in, tell us, articulate what it is about that form that helps you defeat a claim or prove your defense. And it was like,
Right. And Chip, it's particularly important to note that is limited to the circumstances where the plaintiff's not making what's called an informed consent claim.
Right.
If you're making an informed consent claim where you were not properly warned of the known risks of the procedure or the therapeutic alternatives to the procedure,
Right.
more conservative therapies or that kind of thing, then that is a separate claim under the Medical Malpractice Act from just negligence. So you got negligence and you've got informed consent. In Kara's case, her argument was simple, just like your case in Matranga, Chip. We're not making an informed consent claim.
Right.
So why does this form come into evidence? What purpose does it serve?
Right. We
And
acknowledge, yeah.
the real
Use the
purpose-
risk
There is
of
no,
the
there is no
procedure.
consent claim.
But-
Right.
But there is a real purpose why the defense is trying to do that. And to assert the idea that, you pays your money, it takes your chances, and anything that goes wrong, we're off the hook, particularly disastrous consequences like death, brain damage, paralysis, quadriplegia, those kinds of catastrophic injuries. I want to, you raised a word that I think a lot of people don't have a clear understanding of in medical malpractice, and that is complications, known complications, and complications which arise from negligence. Those are different things. Why don't you, Carey, you want to have a go at that?
Absolutely.
What are complications, and why are, I mean, all medical malpractice consequences are complications, but not all complications are medical malpractice. Is that
That
a
is
good way to
100%
start it?
correct.
That's a great way to start.
That is a great way to say it. And look, one of the biggest challenges, and I think Carol would agree with this, and I think you might agree with this, Chip, one of the biggest challenges we face as practitioners on the plaintiff side is explaining to victims or their families a catastrophic outcome is not a medical negligence claim. If we can't show that somebody did something wrong, that is our burden, to show that somebody did something wrong. If we can't show that, we fail, okay? So, but we do know that anytime anybody undergoes a procedure, mostly invasive procedures, but not exclusively, that there are things that can happen even when the doctor does everything right. Bad stuff can happen even in the absence of negligence or bad conduct. That is a known complication. But you're right. If that complication occurs because the doctor failed to act as a prudent physician and did something they shouldn't have done or didn't do something they should have done, that's negligence. That's a known complication, which is the result of medical negligence for which the healthcare provider should be held accountable.
I explain it a lot of times. I use an example of my mother. My mother was getting very old, and she was going to have a CAT scan done, and she'd never had one before, and it was going to be with contrast. And a very small percentage of people are allergic and can have serious consequences to a CAT scan. But she'd never had one before. They asked her all the right questions. Are you allergic to shellfish? And have you ever had one before? Have you ever had a bad reaction? Blah. They did everything, you know. And it is a small percentage. So and she needed the CAT scan. And so they gave it to her. They gave it to her in IV just like they normally would. And within a minute or two, she slid into anaphylactic shock. And they had to rescue her, basically. They had to restart her heart and put her on a ventilator and so forth. A day or so later, she came out of it. She was in a coma for a day or two. It was a very bad reaction. But I tell people, there's no malpractice there. They did everything they could. It's a bad result, but there was no negligence, and that wouldn't be a medical malpractice case.
That's right.
Right.
The burden is on us to show somebody did something they shouldn't have done or somebody didn't do something they should have done.
Right.
Period. And if we can't show that, we fail.
And as I say, in a medical malpractice proceeding, for us as lawyers, you got to have the medicine.
Yes.
You got to have the medicine. A bad result's not enough. And unfortunately, we have to tell a lot of people, as I'm sure you do, I feel so sorry for you. It's a tragedy, but I can't take the case because we don't have the medicine. They didn't do anything wrong.
Right. It's very hard for a layperson to digest that.
Yes.
When they're facing a brain damaged baby, when they're facing the death of a loved one, a spouse, a child, it's very hard for them to accept that. And we as the messengers oftentimes get shot by delivering that message, which I hate to say, but understandably, I can understand how a layperson would struggle to understand this. But yes, that's true.
Now, you talked about a burden, and that among lawyers, we're talking about a burden of proof. And in medical malpractice, we have to show negligence more likely than not was the cause of the injury, right?
Right.
We have to do that. And that is failing to adhere to the medical standard of care, deviation from the medical standard of care, negligence, basically, as you've been saying. But there are some circumstances where even more than, and that's a hard burden in medical malpractice, isn't it? I mean, you need an expert. You gotta spend a lot
At
of
least
money.
one, yeah.
You gotta spend a lot of money to do it, and you're gonna have to probably go up against a medical review panel that
Mhm.
80, 85, 90% of the time finds the doctor didn't do anything wrong, and so forth and so on. So it's a heavy burden, isn't it?
It is, and I'll say that what you just articulated as the burden being more likely than not is legally correct, but practically, I would take the position it's practically incorrect that you almost have to prove it beyond a reasonable doubt to the satisfaction of the jury. That is because jurors still to a significant degree still put healthcare providers on a pedestal. They don't like to believe that healthcare providers make mistakes. So our burden, although you articulated it correct legally, practically, I think it's even stronger.
And I think
Probably right.
Kara, I'd be interested in this. I think one of the reasons for that is if people widely understood that medical malpractice is the third leading cause of death in the United States, that when you walk into a hospital, you have a 1 in 9 chance of being injured or killed by medical malpractice. If they knew,
I didn't know that one, Chip.
Yeah.
I'm going to plug that one into the equation. I can tell you that.
yeah, there's actually, that comes from the
The Johns Hopkins study?
Johns Hopkins and the CMS statistics, the Medicare,
Okay.
Medicaid, has
This
the
is the
data for that.
the government
Yes.
statistics.
Yeah, 1 in 9 chance of being injured or killed. If they knew how prevalent and how catastrophic medical malpractice is, it's really, really scary. And I have a theory, I'd be wondering what you think about this, that one of the reasons that they don't want to believe that a doctor or the medical staff at a hospital is negligent is because it's a hard reality to confront that it could happen to me.
Oh, 100%. I agree with that 100%. I
Yeah.
think that they want to excuse it in some form or fashion because they don't want to think that it could happen to them. The other thing that I think that we try to emphasize in our cases is to impress upon the jury, no one's saying that anyone did anything on purpose here. Okay, like no one's saying the doctor did anything on purpose to cause this outcome, right? He wasn't trying to kill, like in the Caserta case, the Lucas case. No one's trying to kill Dorothy Caserta with the NG tube that morning. Like, no one is saying that. However, they have standards, and we showed they didn't meet the standard. The standard is to exercise care when you're inserting the thing. They didn't do it, or it wouldn't have plowed through her esophagus. So I think it is those things. But yeah, when you talk about jurors and what their experiences are, I think you're right. They don't know the degree to which there are serious bad outcomes in hospitals and the degree to which malpractice affects patient care, patient outcomes. And it's almost too scary. They just don't want to have to think about it.
Don't want to have to think about it. Now, you are both board members of the Patient Rights Advocacy Forum, and one of the things that we want to do, and one of the purposes for our podcast, is to raise public awareness of how prevalent medical malpractice is and how disastrous the consequences can be. This can cause catastrophic injuries. But to segue on the point we just made, a lot of people don't think about medical malpractice until it happens to them. And this is one of the things our organization is trying to mobilize public support, because the healthcare industry's lobbyists in Baton Rouge never sleep. They're always there. They're always thinking of more ways to protect their clients, and they're paid to do it. So, I mean, I'm not blaming them for it, but there's no one really that speaks up for victims. And once you're a victim, it's too late because our laws are so restrictive and so harsh. There's nothing you can do about it once it's happened to you. We need to do it now. And so one of the ways that I think we've seen most recently, where the healthcare industry's tried to protect itself to the extreme, is the Louisiana Health Emergency Act, in which this heavy burden that we have was raised even higher. And why don't you talk about that a little bit? Why don't you start, Kara, because you had a case about this, the Sebel case, that again was a Supreme Court case that was decided in December 2023, so pretty recently. Why don't you talk about this extra burden that the healthcare industry fights for to the last man?
Well, so I didn't know anything about it until COVID hit.
Right.
And I got an email one day. Did you know there's this statute on the books? And so we all go run look at the statute. Of course, I didn't even know there was anything about a statute. And people are talking about, no, there's a gross negligence immunity statute. I'm like, well, wait a second, there's a what? So we all go run and pull it. And basically it says any healthcare provider, shall not be held liable during a time of declared public emergency unless the plaintiff can show gross negligence or willful misconduct.
Which is an impossible burden,
Right.
basically.
What
If we had proof
does
that
anyone know
somebody
what gross
intended to.
negligence is?
Well, no, but that's the funny part, or the tragic part, I should say,
Yeah.
Chip, is this.
The ironic.
So the only way you can prove gross negligence is through the testimony of another physician. And most physicians would say, I don't know what that is. So
Right.
how can I opine on that? How can I give an opinion? I don't know what that means.
Right. They don't discuss it in residency.
Yeah.
They just,
So you're
they
asking,
don't piece and parse out between just regular ordinary negligence and wow, this is whopping gross negligence. Right?
so in effect, what it is, Chip, it's an immunity statute for doctors during COVID. The real bad part about it is that statute applies whether the treatment is COVID related or not.
Whether
I
it's
was gonna-
related to patient care or not.
Patient care or not. Yes, it could be an auto accident. That's right.
The statute, we're bringing that up a lot. The statute was broad enough every bit to sweep up a doctor rear-ending a patient.
Or a slip and fall.
Like,
Slip and
yeah,
fall. Or,
a slip and fall.
Yeah, exactly.
That's right.
Yeah, a
Slip
lot
and
of
fall.
people, I think, would say they have a vision in their mind during COVID of, meat packing trucks backed up to the morgue of hospitals, a huge patients patients lying on gurneys in the hallways because there's not enough beds. The staff of these hospitals working, 20-hour days, to care for people with pneumonia and COVID that are dying left and right. And why don't they deserve some protection? That's I think a lot of people ask that.
Well, first of all, if it's treatment related, and if the treatment is impacted by the presence of the COVID pandemic due to staffing or other issues or inability to meet face to face with the patient or limitations that occur in the doctor-patient relationship because of the existence of the pandemic, there's a very good argument that they should be entitled to that.
Yes.
There is a very good argument. They're working under extreme circumstances which are completely beyond their control.
They may have had a 20-hour day,
Yeah.
and they
They're
forgot
understaffed.
something, and someone dies because
Or
they
the
didn't get it.
patient needed a ventilator and they didn't have any
And-
left.
Right, they didn't know
I mean,
ventilators left.
A lot of
Everybody,
people died because of that. And it's like,
Well,
I don't think that the
there's-
plaintiff's bar could sue in that instance. I would get thrown out, and that should get thrown out.
that should get thrown out. So
And-
the
and
answer
it-
is they
that-
should be under that
that-
circumstance.
But first of all, the state of emergency in Louisiana during COVID lasted for 2 years, or more,
Oh,
like,
yeah.
right? 2
Right.
years. And
Which we're not blaming the governor for, right? Because that's the green light for federal funds coming into the
Right.
state. Was he goes, hey, I've got an emergency, and it releases the
Yes.
purse strings of the federal government. So all the states had some form of this, and no one's blaming that, but it got to a point where it's like, are we really in an emergency and
and this
what's
hardship.
happening?
And I read that in Mississippi, Mississippi had a similar statute, and so did Texas. And Carey, you may know something about this from the Sebel case. Both Texas and Mississippi, though, restricted the gross negligence standard to you had to show a relationship to the treatment for COVID, or if the hospital was understaffed because of COVID, or you had to show some connection between the epidemic and the lapse in treatment, whatever it may be. Louisiana's statute didn't have that, did it?
Not only did it not have it, but as Kara's law partner pointed out in her beautiful brief to the Supreme Court on the case, which is reviewing this issue right now, she pointed out there are 17 states with emergency statutes. Out of those 17, 16 require a nexus or a connection between the COVID and the treatment.
Yeah.
Louisiana is the only state that has no such requirement.
Yes, there was a section of the brief that was titled Louisiana's statute is an outlier, period.
17 states, 16 require a connection. Louisiana is the only state in the country with such a statute does not require a connection.
Now, I can tell you, during really in the aftermath of the epidemic, I believe it was in 2022, I went to the legislature in Baton Rouge, along with several other people, to argue that the Louisiana statute be narrowed down to what these other 16 states have. Yes, you have to prove gross negligence if it's connected to the pandemic or whatever the emergency may be. But no, if it's not connected. If you're having, elective surgery, far away from the emergency. And of course, one would think that the healthcare industry would say, well, yeah, that's reasonable. We can live with that. But they didn't. They fought it tooth and nail. And the Louisiana legislature has yet to narrow that down. But the defense attorneys wanted to take it a step further in medical malpractice. And Kara, why don't you tell them what happened in this Sebel case?
Well, in the Sebel case, they wanted the doctors, like we were talking earlier about how doctors have no training or education in terms of piecing and parsing out what's regular negligence and what is gross negligence. And they wanted these medical review panels to be opining on it, so that our clients I think they thought they would kill more cases at the panel, and that there were basically going to be no killer cases for that 3.5 years at all.
Yes.
To your knowledge, was there ever a panel during this period that found that one of their colleagues, who was the subject of the medical review panel proceedings, has there ever been a recorded single instance of a panel finding one of their colleagues grossly negligent?
So I only know of one. It was in one of my cases, and I had actually objected to Sebel. The Sebel case had not been decided by the Supreme Court, so the Supreme Court hadn't weighed in on whether medical review panels could opine on this or not, and I objected to it, and I said I don't want them considering it. The case was so bad, it also involves a credentialing case against the hospital for giving these doctors privileges. But the case was so catastrophic and the negligence was so gross that
they actually found gross negligence.
And they did it gratuitously, even though I had said, don't do it. They were like, oh no. But I was thinking it's literally the only one that I know of happening.
Now, for our viewers,
there were a number of panel opinions, however, that found, prior to Sebel, found negligence, but no gross negligence.
Right. They had said, that was, I think, what the defense bar was teeing up for a while, right? We'll say, is there a breach? And then we'll say, does it rise to the level of gross negligence?
Yes.
Right.
So the healthcare providers fought this, right? They wanted medical review panels to come back because they thought one case that you know of, Kara, in hundreds of panels that are held every year, one case. So they Yeah, one out of thousands, because this goes over a couple year period. So they want panel doctors to be confronted with having to call out one of their colleagues as grossly negligent, and they're thinking that's not going to happen. Even if we lose the panel, we may lose it, but they won't go so far as to say gross negligence, which is a winner for us because that's the burden we have. Okay, what did this, and they fought it, and the Sebel case went all the way to the Louisiana Supreme Court. And what happened?
Well, the court split 4-3, but the court held no medical doctors are not going to consider this.
At the panel.
This is an affirmative defense. It comes after the medical review panel.
That the statute provides that their only burden is to find whether there was a deviation from the standard of care.
Right.
That's statute. I think it's based on the statute.
Oh, I think it was too.
Yeah.
It's like there's what the defense bar is proposing
Is in conflict with the statute.
is irreconcilable with what's spelled out as their duties are, and we're not going to expand that here because the whole scheme and setup is already in derogation of the rights of injured people. So we're not going to take that a step further for this context because we don't have any legislative authority to do that.
But it was only 4-3, which is
Right.
a little frightening.
4-3. And
Little frightening.
for a couple of years, it caused a lot of confusion among the chair people of the
Yes.
medical
It
review
did.
panels. And
Understandable.
probably a lot of people were discouraged. I know many of our colleagues questioned whether they even wanted to take any of these medical malpractice cases during this period of time because of the heightened. I mean, it's already heavy. I just don't think I'm going to take these cases because I can't. I don't think I can prove gross negligence, whatever
Yeah.
gross
Well,
negligence.
gross negligence is just a hair below criminal misconduct.
Right.
It's just a hair below criminal misconduct. When you put it in that context, that gives you an idea how difficult that burden is.
Right. It's somewhere in between ordinary negligence
And criminal
and
misconduct.
a criminal act, which should have you in a totally different
Okay.
courthouse, right?
Yes.
So,
With different ramifications.
right. And the
Yes.
jurors getting told totally different thing.
And I think I need to add, Chip, which is very important here, in many of these cases, I don't think it's true in Welch, but in many of the cases that have gone up through the courts on this issue, the doctors in those cases have said, COVID had nothing whatsoever to do with my care and treatment of this patient.
Yeah.
The doctors have said that under oath. If this had been before the declaration of medical emergency, care would have been identical. After the declaration, during, it mattered not.
Yeah.
Sure.
And then defense counsel was nevertheless pursuing the argument after that testimony on the record.
Yes.
So with the plaintiff's bar is going, well, wait,
What?
if it really didn't have anything to do with the care and treatment, why are you guys still pushing this?
Exactly.
Hopefully we have an answer from the court soon on
On that.
how that's going to shake out.
And I'm not blaming our brothers and sisters who defend these cases because a lawyer is
They're
a
just
lawyer
doing
is
their
obliged.
They're doing their job.
They're doing their job, and a lawyer is obliged to assert every defense that is reasonable to assert in this case. However, they're acting on instructions from the
From the
hospitals,
client. Yeah.
the mega hospitals. The Sebel case, for example, was being defended by, I think it's St. Luke's.
Yeah, it's a nursing home case. The lady was essentially like starved to death. She had no nutrition. She was not turned. And they finally, when she got taken to the emergency department, the West Jefferson emergency people were like, what have you been doing with this patient all this time? It was like really sad.
So,
sad
I
case.
mean, I guess my point is they'll use the healthcare industry will use any weapon that's out there. And if you try to
I
change
don't
it
blame
to
them. They got a lot too.
They got a lot to work with.
They got lots
They
of
got a lot of weapons.
they do.
The Supreme Court and the
when-
legislature have made sure of that.
and if you try to rein it in, as we did with the narrowing down the scope of the immunity to just cases that involve COVID in this case. Could have been a hurricane. That actually the statute was enacted after Hurricane Katrina,
Yes.
and that state of emergency was much shorter. It lasted
Yes.
some months or something like that. No, we've
And
never had.
much more impactful.
Absolutely.
The hospitals were really
Right.
flooded out.
Yeah.
No
They had no
electricity.
power, they had no electricity. Yeah, yes.
I want to bring you up something. I don't know if you heard about this, but I'd like to get your reaction to it. This is hot off the press, and it has to do with the legislature in the state of Utah. And this is an article March 4th, so it's just a couple days ago.
I've read it.
We're
You know what I'm
familiar.
going to talk about?
Yeah.
Yeah,
Yes,
so-
I think, yes, it's very, very interesting.
So the state of Utah doesn't have a cap.
Right.
It doesn't have a cap on damages and hasn't for a long time. I don't know if they're one of the states that declared it unconstitutional or they just never did it. So one of the legislators in the legislature, Representative Katie Hall, and we won't go into parties and partisan politics here because this really doesn't have anything to do with party politics. It just has to do with lobbying, really, and money. In any event, she decided that she would put in a bill to cap payouts to victims at $1 million. $1 million. And it unleashed a furor. The galleries, they have pictures of it in the paper. The galleries are packed with people protesting. And the headline I read, and I'm not sure which newspaper I'm reading it from, the byline is, quote, "This bill is to protect the rich. Families and patients fight medical malpractice reform." And the bill was killed. In
Utah.
In
Not
Utah,
exactly like
a
Not a
super
blue
liberal
state.
state.
Not a
Not a
blue state.
No. No, and the cap was $1 million. Louisiana's cap from 1975 is 500, is half that.
Right.
And the $1 million cap was described as outrageous. It was described as devastating. And here we have in Louisiana a cap of less than half that. What did you make of that?
I always wonder, where's our outrage? Do you know, like, what?
Exactly. And you know what the problem is, Chip, though? You're right. We have a constituency that is undetermined until it happens to them or a family member of theirs. And now the one thing I will say that is occurring, and I think I see it, and I think we all do, is more and more people are having family members or close friends subject to medical negligence.
We were talking about this last night because I can tell you 20 years ago, I did not have any doctors for medical malpractice clients.
Oh, I
currently-
do. I have two.
I have
I have four.
right
I have
now.
four.
20 years ago, I had none, though.
No,
I think it
that's
is
right.
becoming a much more prevalent problem. And I think it's system failures in hospitals, right? Because I know so many doctors that are terrific at what they do and everything, but like if you're not providing them the support they need, then there's going to be these system failures and things are just going to slip through. And that's what we're seeing.
Or if you're handcuffing them by saying you can only spend so much time per patient,
Yeah,
you know, that because that's about profit, as you said, Chip.
yeah.
And look, at the end of the day, it's about profit.
Yeah, and if a patient walking in with these complaints only gets this test, they don't get this one too, and it's all about money like that. I think that's kind of what we're seeing the past 10 years. I think there's a lot more money in healthcare to be made. And so I think that there's a lot more greed. And I think a lot of it has gone more corporate too, right? Like we don't have the Sisters of Mercy going around with their nursing school who are, basically providing gratuitous medical care to people and educating like a whole fleet of nurses behind, like that's all gone. It's all corporate now, and they're answering to shareholders and they cut corners wherever they can. And I just don't know if, this is getting to be a political discussion, but I just don't know if if it jives very well with the ideal of we want to take care of people and provide them good medical care. It's not always consistent, those goals.
But not only that, 95% of the lay people, Chip, have no clue that there's a cap on medical malpractice claims in Louisiana
That's right.
until it impacts them.
A lot
And
of the
then
legislators don't know about
exactly.
it.
And they're like, how did that get passed? I have a family of a legislator right now, and their father voted for the bill, and I'm like, okay, and like, wow, how did that happen? Well, I'm not sure, but it did, and we got to live with it.
Well, as you probably know, the Patient Rights Advocacy Forum began publishing a newsletter every month to legislators to get the facts out there to them, because a lot of times what few people we have had attempt to change the law or scale back the law are dealing with legislators who have no understanding or background or history of the medical malpractice law. And if they knew, and so we're trying to do that. And one of the takeaways that I have of this thing in Utah that we've been talking about is that if people show up, if victims' families show up, if our brothers and sisters show up at the Capitol, and if our clients who are victims tell their stories. I have a quadruple amputee, no arms and no legs. $100,000 is the most the wrongdoer in his case, and they paid it. That's such a drop in the bucket for this man's needs for the rest of his life. He's only 61 years old. It's tremendous. So I want to leave our discussion this morning on that note, is that what we're trying to do, all of us at the Patient Rights Advocacy Forum, is to get the word out, get people, spread the knowledge of how devastating these injuries are, how prevalent they are, and how unbelievably restrictive and harsh Louisiana's law. These people were outraged at $1 million. I mean, our law is the harshest and most restrictive in the country, and it dates to
Draconian.
1975, and we need to do something about
It's
it.
punitive. It's punitive.
We
It
told
really
her
is.
than I am, and I'm no spring chicken. It's like, it's time to do something.
Yes, like 50 years is a bit
I was born in
long.
1976. Okay, it's like if the law's older than I am, we got to do something with it.
Yeah.
You weren't around when Gerald Ford was president. Carey, you were.
I was. That's exactly right.
I
So,
was too.
Chip, I know, Chip. I know, because I think you and I are about the same age. But yes, and I think half of the battle, just half of the battle, is to educate the public and the electorate as to how draconian the laws are, and let them know this could be you, this could be your spouse, this could be your child.
And the case reports, because I think that if people see some of these cases, like they don't even know that these kind of things can happen, right? I think
That's right.
my husband always says, "Oh my God, I don't want to hear that."
Yeah.
When he go, I'm going to court this morning. What's that case about? Well, this is what happened, and this is the argument. He's like,
They operated on the wrong side.
it's like, I didn't think that happened
And they're
anymore.
still defending it.
They're still defending
They're
it.
still defending it.
Yes.
Right.
So yes, but I
Listen,
think you're right. I think most of the challenge, and the Patients' Rights Advocacy Forum is doing a good job of educating the public and the legislatures. And I might suggest that Utah story might be a real good one to get to the legislature.
Oh, for real.
That would
Just
be
embarrass some people.
that would be a good one to get to the legislators. Read this.
Mm-hmm.
Well, Carey and Kara, thank you so much for spending time this morning
Thank you for having
with
us.
me,
Yeah,
and
thank you.
appreciate everything that you do, the contributions you've made to spreading the word as we're trying to do. And thanks again for being here this morning.
Thank you, Chip.
Thank
Thank
you
you
for
for having us, and thank you for all your hard work. 'Cause
Yeah,
you've
absolutely.
you've taken you've taken the laboring oar on this, and we're appreciative of that.
And we're proud.
Well,
Yes.
you're welcome. All right, guys.
All
Till
right,
next
have a
time.
good day.
Thank you for listening to Bayou Justice. I hope today's episode has given you valuable insights into the complexities of medical malpractice in Louisiana. If you'd like to learn more about our mission or get involved in our advocacy efforts, please visit patientrightsla.com. Your support can make a real difference in the lives of patients across our state. Remember, together we can create a fairer, more just healthcare system for all Louisianians. This is Chip Wagar, and I'll see you next time on Bayou Justice.